Join the only roundtable podcast in compliance with 5 of the top commentators in compliance. Check out the rants and shout out at the end of each episode. Hosted by Tom Fox, the voice of compliance. Everything Compliance is a production of the Compliance Podcast Network.
Everything Compliance is now the award-winning Everything Compliance, having won the Top Talk Show in Podcasting Award by W3. On this episode of Everything Compliance, Tom Fox talks about the Coburn case and the discovery order issued by the district court judge in that matter. Jay Rosen looks at the leadership issues in the Russian invasion of Ukraine. Matt Kelly and Jonathan Armstrong take a look at cybersecurity, ransomware, and cyber attacks from a variety of perspectives. All this, shout outs and rants, and more on this episode of Everything Compliance. Hello, everyone. This is Tom Fox back for another episode of Everything Compliance. So we are going to start across the pond with Jonathan Armstrong. Jonathan, what is on your mind?
Well, thanks very much, Tom. In some respects, it's a follow-up, I guess, to what we discussed on the last blog. And on the last blog, we talked about the increase in ransomware, particularly because of the conflict in the Ukraine and that spilling over from the real world into the virtual. And in some respects, this is a slight follow-on. It's a GDPR case against Tucker's, a law firm in the UK, and they've just been fined not a huge amount of money, about $150,000, after being hit by a ransomware attack. Now, of course, whenever organizations are hit by ransomware attacks, they often think that they are the victim and that as a result they shouldn't have to do anything to report, and if they do have to do something to report, then regulators are going to be sympathetic to them. And I think this case tells us that neither of those is true. If you have data that's in the ransomware attack that might relate to individuals who come within the GDPR regimes, either the EU regime or the UK regime, then you're likely to have to make a report to a regulator. And in some cases, regulators will investigate. Now, I can tell you, having made a probably Ukraine-related report to a regulator this week on behalf of a client, that regulators are somewhat sympathetic to there being a state of war. But in any event, that reporting obligation remains, as we said last time around, whether it's a state actor attacking you or not. In this case, Tuckers became aware of a ransomware attack on 24th of August 2020. They had a ransomware note delivered. The evidence pointed to a ransomware group called Conti. It's the Conti group who said that openly that they were siding with Putin and that they were putting their resources at his disposal to attack targets in the West. Now, Conti have had their own challenges since that announcement was made. Apparently, whilst Conti said that they were siding with Russia, some of the group were based in Ukraine, and they didn't want to get involved, or certainly didn't want to get involved on Putin's side. So Conti themselves, ironically, have been the victim of what seems to be a cyber attack. But as I say, this is a historical episode from 2020, and the gang, if it was Conti, encrypted almost 980,000 files on the law firm's system, and just over 24,000 of those files related to court bundles. Only 60 of them seem to have been exfiltrated by the attacker, but they were released on the dark web. And obviously that's common in the majority of cases. Attackers will take data and they'll try and hold the data to hostage if you don't pay the ransom to have your system unlocked. And the files included personal data and sensitive personal data, now called special category data under GDPR, so data related to criminal convictions, health, this sort of thing. Now, Tucker's told the ICO that part of the reason for the attack was that they'd applied a patch late to fix a vulnerability. And from those breaches that we see, that's a common theme in ransomware attacks. Oftentimes, people get excited in the tech world about things called zero-day vulnerabilities, vulnerabilities that sophisticated gangs knew about, but nobody else did. And obviously, we always see the CEO, whenever there's an attack, they always say it was a sophisticated attack. They never say, we forgot to patch our systems. It was a known vulnerability. The world and his dog knew about the vulnerability. We just not addressed it. And the reality is that it's the latter that's usually the case rather than the former. It was the case here. So the ICO were critical of the fact that they hadn't patched their systems, also critical of the fact that they weren't using multi-factor authentication, what's called MFA, to work out, a password together with a token. So as a result, the regulator, in this case, the UK Data Protection Authority, the ICO, decided that Tuckers hadn't processed personal data in an adequate manner, and they particularly were interested in the fact that Tuckers had asked for a review of their cybersecurity stance under what's called the Cyber Essentials scheme. So it's a bit like a sort of dumbed down version of an ISO assessment. And they'd asked to be assessed under Cyber Essentials in October 2019, so not long before the attack, 8 months or so, but they'd failed that assessment. And the assessment had given them a list of things that they needed to correct, and they hadn't corrected them. So the ICO effectively said, well, that amplifies what we were going to do to you. And they also said some of this data that was subject to the attack, you shouldn't have been storing anyway. They'd said that they were going to store data for 7 years in their retention schedules, but they'd stored data for longer. So again, I guess 3 factors that led to the ICO intervention really. 1, the fact that they hadn't taken technical and organizational measures, so they hadn't patched, they hadn't done MFI. 2, that they'd had an assessment which had highlighted those issues and they hadn't passed it. And 3, that they had held data longer than they said they should have. Now, the assessment piece, I think, is interesting. Quite often, of course, clients or organizations generally try and get assessed for things, and they fail, and they just try and move on and pretend they'd never applied. The Office, that well-known documentary on US Office life, had a predecessor called, surprisingly, The Office. And the lead character in that, the manager, Dunder Mifflin's manager in the US version, had this phrase, if at first you don't succeed, remove all of the evidence that you ever tried. And in the cybersecurity world, I think we know now from the Tucker's case that that just isn't true. If you fail an assessment, particularly if it's an assessment from a quasi-governmental body, in this case NCSC, then you're probably going to have to fess up to that to the regulator. And if you've been told to do things as a result of that assessment and you've not done them, then I think you're going to be doubly guilty when it comes to a regulatory finding. So I think the crux of the case really is that is that you need to take ransomware seriously. You need to have your technical and organizational measures correct. If you do go out and get an assessment, then make sure that you action what it tells you to do. and consider whether an assessment's the right way of doing things if your policies and procedures aren't in place anyway.
Early on in my compliance career, I was confronted often with, well, gosh, if we do that and we find something, we have to fix it. Is that kind of mentality still exist in the GDPR, data protection, data privacy world?
I think that's right. And I think if you're not an organization that's mature enough to sit the test, then don't sit the test. It might be the same. I don't know what the system is in the US, but here, for example, with driving tests, if you want to go out and drive on the road, you have to sit a test before you do so. And normally we have driving instructors. The driving instructor will do a mock test. If we're not good enough to sit the test, he won't let us sit the test. I think we need to adopt the same mentality with things like compliance and with things like cybersecurity. If we're not mature enough to sit the test, don't sit the test, because not only will a failure embarrass you, but it's also something that you may have to disclose to regulators further down the line.
Your example of the driving test is extraordinarily personal to those of us in the state of Texas this week because a 13-year-old driving a pickup truck crossed the road, caused a crash, and 9 people are now dead. So, on that bit of cheery news, anyone else have a question or comment for Jonathan? Well, then, Mr. Kelly, America's finest from Boston. What do you have for us this week?
Well, Tom, I'm going to pick up a bit on what Jonathan had been talking about, cybersecurity. So we have a suite of proposed new rules from the Securities and Exchange Commission about mandatory cybersecurity disclosure. And these rules are only proposed right now. They are out for public comment until I think early May. When will the SEC then adopt them for real? We're not sure. How might they differ from the proposals, which I will get to in a moment, versus the final rule that they might adopt sometime in the future? We don't know that either. But the proposed rules, as they were first floated, I think on March 8th or 9th, are definitely worth compliance and corporate governance officers' attention, because there's some pretty tricky stuff here that if the SEC passes this and essentially, the substantively the same final form as what we've already seen, I think this is going to be some pretty tricky stuff for compliance, IT security, and risk managers to get their arms around. So we can carve these requirements into 2 camps. First, in your annual report, you would be required to disclose the board's cybersecurity expertise and how the board handles cybersecurity. You would need to disclose the company's policies and procedures for managing cybersecurity risk, and also management's role in implementing cybersecurity policies and procedures. Then you would also need to update previously reported material cybersecurity incidents, which brings us to the second big part of the required disclosures. It would be that in addition to all those annual disclosures I just listed that you'd have to make in the 10K, you would also have to report within 4 days of any material cybersecurity incident. Now, it's not 4 days from when the incident happens to filing an 8K, announcing it to the world. It's 4 days within deciding, okay, this incident we had, this is indeed material. Now we have 4 days to file the 8K. Let's assume you did decide it's material. What would you need to actually report to investors, open to the world, when the incident was discovered, whether it's still ongoing, a description of the nature and the scope of the incident, whether any data was stolen or accessed or otherwise used for illicit purposes, the effect of that incident on the company's operations, whether you have already remediated the incident or you're still remediating it. So if it's a material thing, you have to disclose all those facts, report it within 8 days, and then once a year, you'll need to disclose your basic approach to cybersecurity and an update on all those previously listed, previously reported incidents. So I got 2 big questions here. First, well, what is the SEC trying to do with all of this? it looks to me, it feels to me a lot like how the SEC was trying to drive board attention to financial reporting risks with the Sarbanes-Oxley Act, where suddenly you had to disclose how is the audit committee overseeing risk management and internal controls, who is the designated financial expert on the audit committee, and things like that. So the SEC's disclosure rules, way back when, almost 20 years ago now, transformed how the board and the audit committee were thinking of financial reporting risks. I think the SEC is trying to do the same for cybersecurity risks. In the same way that all companies cannot prosper without effective control over financial reporting, really, in the modern world, all companies cannot work well without effective control over cybersecurity. So, how's the board thinking about that? That's where the SEC is trying to go. What is interesting to me is that, at least with financial reporting and the transformation that we had right after the Sarbanes-Oxley Act in the early 2000s, we had the Sarbanes-Oxley Act. The SEC had clear legislative direction from Congress. You have to go and do this. And we don't have that with cybersecurity. So there are people who are already wondering whether the SEC is drifting outside of its lane. And the last lone Republican on the SEC commission, Hester Pierce, she objected to this proposed rules. And she specifically did say, this is not like SOX. We are really trying to drive how companies govern cybersecurity risks when that's not what the SEC is supposed to do. It's about capital markets oversight and disclosure to investors. But still, I think the SEC is going to enact these rules. And I know they'll enact some sort of a rule. I'm fully confident of that. I think substantively, they're probably going to be pretty similar to what we've seen in the proposal. But how are boards and senior managers going to be thinking about this? That's going to be a big sea change that you'll have to start trying to address. And I get it. A lot of boards already do worry about cyber. They already do have at least one cybersecurity expert on the board, but it has been a case-by-case basis of how each company is trying to address this. Now, here comes the SEC. They're going to try to put some actual structure around this. I still expect, like all SEC rules these days, it will be challenged by somebody somewhere in federal court, and we'll see how it goes. But it's really interesting to see now that the SEC is getting in on the Cyber Act too. My other big question, and this is the last of it, is let's get back to that material cybersecurity incident. If you have one, you have to disclose it within 4 days. Many people here might be wondering, well, okay, what exactly is a material cybersecurity incident? That is an excellent question, which the SEC's proposal does not answer. And I think it's going to be really frustrating. But I can see the challenge is going to be, how do you develop a structured, repeatable, defensible process, an objective process, to decide whether a cyber event is material or not? Because you could very easily have something that is not very widespread, but potentially could lead to a lot of liability. Well, that's material from a legal perspective. But your IT people might say, well, we didn't lose all of our customer records, so it can't be material, right? That's the sort of challenge that companies will need to be thinking about. You're going to need really good IT forensics capability from the CISO's wing of things to understand what are the actual facts of what was breached, when was it breached, how was it breached, what controls didn't work that it did get breached, how much data did we lose. Very forensic, fact-driven assessment there. And then you're going to need the compliance and legal people to also say, well, on a legal basis then, how would we analyze whether this is going to make a reasonable investor change their total mix of information? That's the Supreme Court's standard. If somebody can clarify that in plain terms, please let me know, because I don't know what it means. It's going to be a sort of case-by-case judgment, and I think that's going to be really painful. But if you are assessing this by whim from quarter to quarter and breach to breach, I think that's going to be a real problem. So I can also see then, aside from these board-level treatments of cyber, what's the tactical process you're going to have to evaluate whether a cybersecurity breach is material or not? Who makes that decision? Who doesn't? How does that relate to, say, your disclosure requirements under state or national privacy rules? Unclear. How would this apply if law enforcement has already told you, please don't disclose this yet, because we might actually get these bastards who zapped you and they're going to get the money back? The SEC rule doesn't say that either. It specifically actually does say that law enforcement investigations alone are not going to be enough to justify not disclosing this. So you might have to disclose something under SEC rules that the FBI has already asked you, please don't disclose it. And what are you going to do there? And what if state law says you don't have to disclose it, which in many states in the United States, law enforcement requests are grounds for not disclosing a breach. Big jurisdictional mess as well. And we don't have good answers for that either. So on that chipper note, I just wanted to kick that issue into the field and see what people might think. But I do believe it's going to be really tricky. And Jonathan, I know you probably have something to say. However, for the record, over here, it looks like I can't hear or see what you are saying. So somebody might need to translate Jonathan's question over to me.
Well, Jonathan, you want to pitch the question to Matt and see if he hears it?
Yeah, I will do. Yeah, I think. I mean, Matt's configuration of this, I think, is true. It just is a mess, it seems to me, and I think there's an interrelationship with GDPR and the stuff I've talked about. You know, if a US listed entity is potentially subject to a fine of 8% of its annual revenue, almost how is that not material? And so I think that's going to be one element of the equation. And the other bit I think that you said, Matt, is definitely true, is that GDPR has a reporting requirement of 72 hours. Going to be 4 days in your case. But it's almost impossible to work out the effects of an attack. If you look at something like ransomware, you don't know a lot in the first 3 days. Sometimes you don't know a lot because the organization doesn't have the right systems to detect the harm. So, how are regulators going to look at that? I think from a GDPR point of view, they say, well, if you didn't have the systems to work out whether how big the harm was, then you don't get a pass for that. So, in cases like Tucker's, they take into account the fact
Tom,
that
I can't hear you.
they didn't have measures. But yes, I think you've raised quite a lot of questions, and I'm conscious that Matt can't hear me. But the only other thing I would say is that, of course, there's more legislation on the way in Europe. There's something called the Nis2 Directive. That's likely to get more traction because of incidents in Ukraine. It's addressed really to critical national infrastructure providers. There is already a directive called NIS. That'll be extended, maybe not in the current French presidency, but it'll definitely be on the Czech agenda given their proximity to Russia. So I think there'll be more legislation in Europe as well as the stuff that Matt's talked about. And I'm conscious that Matt can't reply because he can't hear me. But I will just stick a thumb up and say, well done, Matt.
So you got a big well done from Jonathan, Matt. Let me see if I could translate into shorthand a couple of his points. Number one, if your fine or penalty is a percentage of your annual turnover as defined under GDPR, does that make any breach material? Interesting question. Number two, the GDPR time frame for not responding, but notification is 72 hours. Here it's 4 days. And Jonathan's point was that often in the first 3 days or even 4 days, you do not know the extent of the breach. It could be because you're actually doing forensic testing to determine the extent of the breach, but it could be if you don't have a plan and process in place and a critical response team in place, then you may not even be able to ascertain that you have been breached. I mean, Equifax is the most prominent example to me, or Target even, and they didn't know for months they'd been breached. So even when they make that determination, it's still an assessment period to determine the extent of whether your files are locked up and you have to pay a ransomware, or personal identifiable information can be released. So, as a lawyer, I love the materiality standard because all it's going to do is drive litigation. Um, but I do see certain practical problems, and um, I guess, Matt, who's going to decide materiality eventually? Or at the end of the day, is it going to be the SEC? Is it going to be the Delaware courts on shareholder actions? Or is it going to be some state district judge in a place like Texas?
That is all unclear at the moment. Now, one thing that we do know that the proposed rules are clear about, you have 4 days to file your disclosure with the SEC from the day you decide, yes, this is material, not from when the breach happens. If it might take you a week or more to figure out if this is material or not, the clock is not ticking. But once you, the brain trust in your corporation, stare at each other in the conference room and say, yeah, this is material, then the clock ticks. And then you have 4 days to file the 8K with the SEC, and it goes from there. Um, I think that's an excellent point, that if you're looking at 4% of global turnover in a GDPR fine, would that be material? Yes. I mean, at 4% of anything would be material, period. But that's not going to be decided for many, many moons after the incident, and after probably the incident is published and it's material anyways, or it's disclosed. So I wouldn't necessarily worry about it that way. But are we talking about remediation costs? Would that be material? Well, how would you know what the costs would be in the moment? It's a really objective problem. And I think it's actually more challenging if it isn't a privacy breach per se, but let's say you forgot to update your SAP controls, and hackers came in and penetrated the general ledger and executed a wire transfer of $100 million and wired it off to parts unknown. I could say that's material on the money. That's material because you have a glaring weakness in your internal control over financials if you are not updating your SAP systems or Oracle or whomever. So, you could wind up with a really big problem. Or, what if they wire away $4 million, which is not material, but if you're not updating your ERP software, that's pretty stupid. And that sounds like a material failure of your brain cells to me. So, how would these cases actually work? I think a lot of it is going to be, it when you see it. And a lot of it is going to be kind of struggling to put together a good disclosure materiality review process. And the SEC has been very hot to trot talking about what is good materiality assessment these days. So I think that this is going to be a painful thing, but the SEC is looking at it and wants to try to figure out a better way.
We are going to have a quick word from our sponsor, and we'll be right back. So I'm going to actually have some remarks today, and what I want to talk about are some legal issues around the Fcpa that have come up in a couple of different cases, in a couple of different instances. The first one is the Timothy Leisner testimony at the Roger Ng trial in New York City. Roger Ng was a managing director at Goldman Sachs and was integral to the 1MDB fraud and bribery scandal. He was the person who allegedly brought J. Lo into the picture, at least from the Goldman side of things. His boss was Timothy Leisner. Timothy Leisner has pled guilty to Fcpa charges against him and has agreed to forfeit some $44 million in profits, and is now testified in the Roger Ng trial. It has been, as I often ask our recovering screenwriter colleague, Jay Rosen, Jay, if I told you that somebody was married to two women at the same time, would you believe that for a screenplay? He goes, well, yeah, I've heard of that, Tom. Well, now, if I told you that husband impersonated wife one to wife two, how would that go? Well, Tom, you're kind of out there. Well, that's the situation we had with Timothy Leisner. While being married to two different women, he was impersonating them in emails traffic. And he is perhaps one of the greatest serial liars that has taken the witness stand. And that's in a series of great serial liars over the years. He admitted he was a serial liar, and he admitted that he would lie about anything. So his current testimony, whether believed or not, is yet to be determined, is that Roger Ng was the mastermind who brought J-Lo in, who circumvented the massive amounts of internal controls at Goldman Sachs, who was part of a meeting in London where J-Lo identified in writing the people that needed to be bribed. So after Goldman Sachs did the bond deals for 1MDB that they could steal the proceeds from. His testimony lasted 5 days. It was withering cross-examination, you might guess, but it really brought up a couple of different questions for me. Number one, just how difficult is it to get a conviction under the Fcpa? And I say that because if the only evidence of Roger Ng's involvement is the testimony of Timothy Leisner, meaning there's no written documents, there's no exhibits presented which back up the testimony of Timothy Leisner, a jury could just say, this guy is just a liar and we're not going to believe him. We're going to throw out everything he says, and there's no basis to convince Roger Ng. Was Roger Ng a part of the scheme? Well, yeah, he was. Timothy Leisner was the face guy who did all the work, the relationship work, and Roger Ng did all of the work within Goldman Sachs to get everything through somehow by hook, nook, or crook, circumvention, lying, or other. But that seems to have been that part of his work on this matter seems to have been lost. How do you, as a boss, testify that it was your subordinate who actually really ran the show? That's a pretty difficult sale. So I've been really interested in watching that. This trial has been something that rhymes with hit show for one other reason. And that was because somehow the government failed to turn over 15,000 documents to the defense relating to Timothy Leisner and the evidence for Roger Ng's defense team. The trial team blamed the discovery team for failing to do so. When you blame another part of your law firm for your screw up, that's just not something you do. And here the Department of Justice did that. The court has not ruled. They did grant a 5-day continuance to allow the defense to go through the documents. They have not, the defense has not moved for a mistrial. I would have expected that almost immediately. 15,000 documents is a lot to go through and prepare a cross-examination on the most critical witness. So we've got that going on. Of course, the court's yet to rule on that. So, and what's going to be the impact if he is found not guilty for whatever reason? If the jury doesn't like Timothy Leisner, they don't like the government's case, they don't find it credible. It goes to show, with as much evidence that is now in the public record and Goldman Sachs' internal investigation and Goldman Sachs' guilty plea, none of that may be enough. If the DOJ is going to go after individuals and they can't get a conviction on a case like this, that does not portend well for potential other cases. And that really brings me to the second case, and that's Coburn. Coburn was one of two individuals who were officers of Cognizant Technologies. Cognizant Technologies received a declination from the Department of Justice in spite of the fact of the allegations of the CFO and General Counsel being part of a bribery scheme. And those two were criminally indicted. Now the Department of Justice is going to trial against those two individuals. We're still in the discovery stage. The court, in a discovery dispute, ruled that not only does the government and Cognizant have to turn over everything that Cognizant gave to the government in terms of reports, interviews, materials, and presentations, but they have to give up all of the underlying data. So, for instance, Cognizant's lawyers made summary reports of interview testimony or interviews of Cognizant employees to the government. Well, the court said you've got to turn over the actual interviews, the entire interviews, all of your work product. Anytime you turn over anything that you claim is attorney-client privilege to a third party for whatever the reason, that waives the attorney-client privilege, and that's what's happened here. The ruling is probably not that surprising. That's longstanding law. If you turn over attorney-client privilege materials to a third party, that waives a privilege. But here court also ruled that attorney work product privilege doesn't exist. So this is going to put a lot of pressure on, at least in this group, people like Mr. Armstrong who have to do internal investigations because you have to have a process. You have to follow that process, and you basically have to get it right, because if you report to a regulator, your underlying work to get to that opinion is probably going to be discoverable if there's a criminal proceeding, at least in the United States. So it's going to put a lot more pressure on investigations. It's going to put a lot more pressure on companies. And now the government, tying back to my original point on Mr. Leisner, if they're going to try and move forward on prosecuting individuals, they're going to have to turn over a lot more information, which could be exculpatory, particularly if companies don't focus on those individuals in the underlying investigation. So it would not surprise me that if Goldman Sachs focused more on Timothy Leisner, given his role in this. So lots to think about. I don't really have any answers, but I do have some questions that I want to pose out there to our audience. All right. Well, Mr. Rosen, what do you have for us?
I'd like to share some thoughts with you on corruption and leadership. And first off, I'd like to reference an article by Professor Matthew Stevenson, which appeared last week on the Global Anti-Corruption blog. It's entitled, "Hooray for Corruption in the Russian Military." In trying to slow the Russian army's advance and deny Russia control of major cities and other targets, the Ukrainian military may have the help of an unexpected ally, corruption. The corruption, that is, of the Russian military and defense sector. Without taking anything away from the skill and bravery of the Ukrainian armed forces, many analysts have noted that the invading Russian force appears to have been hampered by cheap and poorly maintained equipment, shortages of fuel, rations and other supplies, and deficiencies in training and coordination. And some of these analysts have suggested, while no one factor can explain Russia's poor showing, pervasive corruption in the Russian defense sector may be the culprit. That probably shouldn't come as too much of a surprise. The adverse impact of defense sector corruption on military effectiveness has been well documented, and corruption has been pervasive in Russia. True, if corruption or other factors have undercut the effectiveness of the military, that was not so evident in previous conflicts, such as Russia's suppression of the revolt in Chechnya, its war with Georgia, its intervention in Syria's civil war, and its earlier invasion of Ukraine in 2014. But as numerous commentators may have observed, the current war in Ukraine is an altogether different beast, and Russia's deficiencies in areas like operations and maintenance, logistics and training, these areas where widespread corruption are most likely to have an impact, are showing up much more clearly in this current conflict. Just to elaborate a bit, commentators on the Russian military affairs have highlighted the following corruption-related problems facing the military in Russia right now. Most directly, procurement-related corruption may be to blame for reported shortages of food, fuel, and other supplies. Fuel in particular, which Russia ought to have in abundance, given its natural resource endowments, is often sold in the black market. Next up, corruption in the form of embezzlement and bribery. This can also lead to the purchase of substandard equipment, for example, by giving the contract for equipment and maintenance to a less qualified supplier who is more than willing to pay kickbacks. The same type of corruption can also affect investment in troop trainings, especially in positions where they require a high level of skill, such as combat pilots. And finally, at the higher levels, corruption may undermine the quality of leadership on both the military and civilian side. When people are promoted based on connections or their willingness to get along or doing favors for the right people, they tend to be less competent on average. In ordinary times, all of these problems, which are not unique to Russia, are cause for concern. And that's why many in the military and the national security community have been emphasizing for years the importance of tackling corruption in the defense sector. As such, corruption is not just immoral and wasteful, but as we see now, a danger to national security. Under current circumstances, though, Professor Stevenson is somewhat grateful for the corruption of the Russian defense sector, and he hopes that problems in the sector turn out to be even worse and more consequential. To be clear, he doesn't think we should exaggerate the impact of corruption on the current conflict. Yes, the Russians have had logistical and operational problems, but the main reason for this unexpected slow pace of Russia's military advance has been Ukrainian resistance, and he doesn't want anything in his post to be misconstrued as detracting from that. And the Russian logistical problems themselves have multiple causes. Corruption is only one, and maybe not even one of the most important. Still, he does think it's interesting that at this one time in history, all of these problems that anti-corruption experts and national security specialists have been emphasizing for years do seem to be manifesting in the current invasion. I also wanted to share another view on corruption and leadership from Ukraine. Earlier this week, Tom Fox and Matt Kelly recorded their Compliance into the Weeds podcast with special guest Timur Tim Kazanov-Badarov, a compliance officer and anti-corruption officer in Ukraine. First, a little bit about Tim himself. He's a Ukraine native, and over the years, he's held compliance jobs in Ukraine for companies like DTEC Energy, Reedy's Lab, and the Nis2 Group. He has also been co-chair of the compliance group for the American Chamber of Commerce in Ukraine and a lawyer with the international law firm Baker McKenzie. Matt had two overarching takeaways from this conversation that I think are relevant. First, we can draw a straight line from corruption that extends from the ethics and compliance programs that try to fight the horrors of Vladimir Putin has unleashed against the Ukrainian neighbors. Here's the logic. Corporate corruption encourages political corruptions. It provides the sustenance that corrupt governments need to thrive. Those corrupt governments then systematically dismantle other institutions that might serve as checks on the government's predations. Without these checks, the corrupt government descends into despotism, and the country itself ultimately becomes a failed state. Finally, for lack of any other way to project legitimacy, these corrupt and failed leaders engage in reckless exploits. That horrible sequence of events may unfortunately take decades to unfold, but it's all the same sequence. It all exists on the same spectrum. When we, politicians, businesses, governments, countries, allow the first steps to be tolerated and participate in corruption, then we take the first steps on a path that can bring the world to places like we are today. Hence, corporate ethics and compliance programs are so important. Even though they often come up short, even though they're difficult to implement, and even though the world will never be free of corruption, we need to slog forward to the ideal every day. Or as Tim said, corruption is a cancer for the state. Eventually, they can't do anything except corruption. The second leadership of President Zelensky demonstrates principles of corporate culture and trust that can benefit any organization. There's a school of thought in military strategy that in successful campaigns, senior officers set a few big strategic objectives and spend most of their time fostering strong lines of communication and trust with the battle unit. Junior officers get to make most tactical decisions, which lets them respond to shifting battlefield conditions. There are a lot of parallels between that idea and Zelensky's wonderful leadership. He has defined the core objective, which is preserve the Ukrainian state and protect their people. Through his heroic commitment to defending Ukraine, he has fostered deep bonds of trust with his people. But the actual defense of Ukraine, that is, it seems he is leaving to local military units. In contrast, Putin has followed an opposite course. He has defined no clear objective beyond some half-baked delusions of a new Russia. He hasn't fostered clear lines of communication, and he never built bonds of trust among the army. On the contrary, the corruption that ravaged so much else in Russia ravages the army too, with faulty equipment, outdated rations, and shabby uniforms, and a dozen other problems, some of which I enumerated above. So, should we really be surprised that Ukraine, under Zelensky's leadership, has held on successfully and valiantly against a larger foe? Probably not. Corporate leaders would do well to consider the same lessons about leadership. The more senior leaders define what their organization is about and encourage clear lines of communication and trust, the better your organization's performance will be. Then corporate leaders need to turn those ambitions for strong leadership to a commitment to avoid corruption whenever possible. The world today and tomorrow will thank you for it. And Matt, Tom, and I encourage you to listen to the podcast they recorded with Tim, and we will include a link to the show notes so you can hear the story directly from him. Thank you.
So we're going to now turn to our fan favorites of Shout Outs and Rants, and we'll keep the same order. So, Jonathan Armstrong, do you have a shout out and or rant for us?
I have a shout out, and it's for Marina Oysanikova. And who's she? Well, she's the news editor of Channel 1 TV, who appeared behind her anchor with a sign telling the Russian people that they were being fed lies on the war in Ukraine. And it's somewhat personal for me. I was in Moscow working in 2013 when I think we had the first taste of this power grab from Putin. I was sort of in a bar on Tverskaya, the main drag in Moscow, when I kid you not, we were literally shook at the table by tanks rolling past as Putin had decided to sort of step up the May Day parade as a show of force. And accompanying that, he had what I guess you'd call it a media whiteout, almost the opposite of a blackout, in that every channel, radio and TV, was told what to broadcast. And it was sort of like a State of the Union address from Putin himself, which went on almost the entire afternoon as he had questions from selected individuals who coincidentally happened to have a TV crew in their living room when they thought of a question to ask him. So it was the most absurdly orchestrated event, and it showed me, I think, the level to which Putin controls and controlled the media. And obviously, things have got much worse since. And so Marina had a really clever approach, I think, not only by making her stand, but also pre recording a video to explain what her stand was about. And that video was released by a human rights group just after she appeared live on Channel 1. She faced for that a penalty of 15 years in jail under Russia's new legislation. And that was obviously a significant thing for her. She's two children, and she was making a real sacrifice. It's safe to say that she's not going to work in Russian TV again. But it was also interesting, I think, the outpouring of support that came for her. 40,000 comments on her Facebook page from a nation that restricts the use of Facebook. She was questioned for 14 hours in a police station after the event. She was denied legal help. So far, she's only had a $280 fine. But I guess with any repressive regime, it ain't over until it's over. And she faces potentially further jeopardy. But the important thing, I think, to say is that Putin has said that at this time he's looking for true heroes of the Russian nation. He's looking for true patriots. And he's just found one. He just doesn't realize it yet.
Matt Kelly, do you have a shout out and or rant for us?
Oh, I have a rant this week. I do this month. My rant is against West Virginia Senator Joe Manchin, the supposed Democrat who still miraculously spent most of 2021 dragging out and torturing the Biden administration and Democrats' policy agenda and then vetoing or voting against or pulling support from the key moments of that agenda. And now he is back again doing the same thing in 2022. Earlier this week, Joe Manchin said that he is opposed to a lot of investment in electrical car infrastructure because he remembers the 70s and he remembers the shortages of the gas lines in the 70s. And he does not want to see people lined up at gas stations waiting for batteries for their electric cars. And that's his big issue, is that where are we going to get all these batteries? And are people going to wind up waiting in line and there will be shortages and rationing of car batteries? Allegedly, blissfully unaware that that is not how electric cars work. There is only one battery. It is in the car forever, and you just recharge it. I thought everybody knew that. I strongly suspect that, in fact, Joe Manchin does know that, and he really is just trying to play dumb to impress the coal interests who pour millions of dollars into his campaign accounts and his pockets, and is doing a disgraceful job representing his constituents and the public at large, and all the future generations who are going to have to clean up our climate change mess. And here's this guy coming up with this wackadoo understanding of how electric cars supposedly work, when in fact that is not at all right. So Manchin, please either get with the program, be honest about what you do know, or just get out of the way and get on with letting the rest of the government take climate change seriously and governance seriously, and stop playing these dumb games with people like what you did this week with the car batteries. Ridiculous.
So I'm going to rant this week about Texas Attorney General Ken Paxton. I previously talked about his corruption, his allegations that the laws of the state of Texas don't apply to him because he's an elected official, but he's taken it an even step further this week. The background to this is the governor of Texas, Greg Abbott, decided that transgender children are not only inherently evil, but that parents who support their transgender children by allowing them to trans are committing child abuse. And he directed the state child protective service, CPS, to begin investigations of any parents who allow their children to transition to a different gender. 8 investigations were opened, and those families went to court to stop those investigations. There's no law in Texas that prohibits that, and the CPS was instructed not to follow their own procedures for investigation of child endangerment. And the state district judge granted an injunction against the state of Texas and the attorney general. And in Texas, when you get a temporary injunction, is because the court believes you will ultimately prevail at trial. So it's a high burden. It's pretty strong if you get it. And Ken Paxton said, you know what? I'm the attorney general. That doesn't apply to me. I'm going to appeal it. And so for one more time, our attorney general has held himself above the law and says these investigations will continue. So, Ken Paxton, you continue to not only be corrupt, but you continue to violate the laws of the state of Texas. Jay Rosen, what do you have for us?
I will keep us in the great state of Texas, Tom, and I have a rant that's going out to Mark Cuban, Shark Tank maven and owner of the Dallas Mavericks. Former Dallas Mavericks general manager Donnie Nelson has sued the team, alleging that he was fired because he had reported a sexual assault and harassment incident. The lawsuit alleges that Jason Luton, Mark Cuban's chief of staff, sexually assaulted Nelson's nephew at the NBA All-Star Weekend in Chicago in 2020. Nelson in his lawsuit says that Jason Luton, described in the lawsuit as Cuban's right-hand man, who still works for the team, assaulted and harassed Nelson's nephew in a hotel during the 2020 All-Star Weekend in Chicago. The nephew, a man in his 20s who's not identified in the lawsuit, had been invited by Luton to his hotel room to, quote, discuss job possibilities, unquote. Luton asked Nelson's nephew to sit next to him and then sexually harassed him. Nelson says in the lawsuit that he found out about the incident 5 months later after his nephew and the team had reached a settlement and Nelson had begun discussing a potential contract extension. He then confronted Cuban about the incident, and as a result, Cuban withdrew the team's 10-year, $66 million contract. He also says that Cuban offered him $52 million to sign a confidentiality agreement about the assault. Nelson filed a complaint with the Equal Employment Opportunity Commission in December, and that lawsuit alleges that Cuban may not have disclosed that complaint to the NBA. Sexual harassment is no joke, whether it's in the NBA or the NFL, and it appears that Mr. Cuban has taken an ownership cue from the head of the Washington Commanders, Daniel Snyder. When we can predict how the story goes from just reading the first few words of the headline, we need to hit the refresh button and take a look at these horrible incidents through a different lens. We need to get rid of NDAs so we can let the light shine in and let the truth shine out. That's what I've got.
Well, gents, another great episode. Sorry for the technical difficulties, but I look forward to our next session together. This is Tom Fox again. Thank you for listening to this episode of Everything Compliance. If you're interested in the Shout Outs and Rants as a separate podcast, we now have that available as well, so you can check that out. I'm extraordinarily pleased to announce a new 5-part podcast series on Taxman, the intersection of tax and compliance. If you've ever wondered about the role of tax in compliance, not simply tax compliance, but tax in compliance, this is the podcast series for you. I speak with noted tax expert Tracy Howell on a wide variety of issues such as tax and compliance, why tax needs a seat at the table, transfer pricing, supply chain, and other topics. I know you will find this podcast series very useful and actually entertaining. So please check out Taxman on the intersection of tax and compliance on the Compliance Podcast Network. Also, please check out my 5-part podcast series, Trial of the Century, the Enron Trial with Lauren Steffi, which premiered in January. You can find it on the Compliance Podcast Network, iTunes, or wherever great podcasts are hosted. Everything Compliance is a production of the Compliance Podcast Network.
This podcast is a part of the C-Suite Radio Network. For more top business podcasts, visit c-suiteradio.com.